Appreciation of evidence in civil trial. So all officers must have experience of civil trial while conducting cases as a trial court. Is it so? All of you have experience of conducting civil trial as a trial court. Then all of you are aware that in what manner the evidence of the parties may be appreciated and what would be the mode of scrutiny of the evidence or appraisal of the evidence. Same principles apply here also, because for appreciation of evidence, firstly, we have to classify the evidence. One is oral evidence and other is documentary evidence. The mode of appreciation of oral evidence and documentary evidence are different. But Evidence Act is only one act under which all the civil trials are required to be conducted and evidence are to be appreciated or scrutinized. So there is nothing more in a appellate stage than what you have already did in the trial stage. The only difference is that in hierarchy, you are in upper pedestal. You are an appellate court. And appeal is a continuation of suit. This is settled principle of law, and I think all of you must be aware of it, that appeal is a continuation of suit. So every provision which is applicable to the trial is also applicable in appeal, civil appeal also, so far as manner of appreciation or scrutiny of evidence. Either it is oral or documentary. So what is the purpose of appreciation of the evidence? Purpose is that as per Evidence Act, all of you are aware as experienced officer that the Evidence Act has been enacted for the purpose that who is the party upon whom burden lies to prove the case. Because it is settled principle of law that one who asserts something has to prove that thing. When the plaintiff approaches the court on the basis of certain factual statements made in his pleading, that is plaint, then prima facie he is supposed to support by evidence. It may be oral or documentary evidence. Similarly, the contesting party defendant who filed his pleading, the written statement, he is also supposed to assert something in his own favor, make out a defense in order to defeat the claim of the plaintiff, or he may make out some cases, and especially with regard to the amended provisions of Order 8 CPC, now every defendant has got right to make a counter claim. Earlier, before amendment, it was confined only into money suits only. So in every suit nowadays, defendant may also set up his own case by way of set-off or by way of counter claim. If there is a set-off and counter claim in any case, then certainly for that part the onus is upon the defendant to prove it. In this scenario, the duty of the court is not just like an umpire to accept one contention and to reject other contention. The duty is of the court is to find out the truth on the basis of the pleadings of the parties and after a scrutiny and appraisal of the evidence, oral or documentary, adduced on behalf of the both parties, and then to give a definite finding on particular issue.
Recording in progress.
So this principle is to be taken into consideration in every trial. So firstly, how the evidence would be appreciated is that each and every evidence, means every documentary evidence and every oral evidence, has to be gone into, examined by the court, and to find out whether it is in consonance with the pleadings of the parties or not. That is first principle. Because variance between pleading and proof is no evidence. It must be in consonance with it. Whatever case has been made out in the pleading, that has to be supported by evidence. All the facts stated by the parties may not be based on any document. So if there are certain facts which may be proved by document and documents are available, then parties usually file such document. The document has to be examined in the same light and in accordance with the provisions of section 65, 67, 68 and onwards relating to the documentary evidence. So far as documentary evidence is concerned, there are two types of documentary evidence. One is private document and other is public document. Public document are those documents which are defined under section 74 of the Indian Evidence Act. So far as public document is concerned, the only difference between public and private document is concerned that the formal proof which is required in a case of private document is not required in the case of public document. It is directly admissible in evidence. Public document is directly admissible evidence, and private document has to be formally proved in accordance with the procedure prescribed under the Evidence Act. Means if any document is written in the pen of someone, it is signed by someone, then it has to be proved before the court by that party who tenders that document that this document was written by someone and it has been signed by that person, or it has been written by A and it has been signed by B. Not only this, in furtherance thereof, he has to also prove that I know the signature of the maker. And how he knows the signature of maker has to be also explained. Whether he was in writing terms with him, whether he was a classmate, whether he was his office mate. There must be some competency to show, because there are three provisions under Evidence Act, section 45, 46 and 47. So far as proof of the writing and signature on any document of any person is concerned. Because all of you are aware that experts are supposed to be the scientific, knowledgeable person who has a specialized knowledge about identification of the writings of any person. So normally, where some documents are tendered in evidence, experts are not being examined. Common witnesses are being examined in a court, and those witnesses who comes in doc, he says that I know that this is a document, so and so document, describes the documents, and this has been written by such and such person, it has been signed by such and such person. So there are three possibilities. Either he is the person in whose person present the document was signed, prepared, signed, or he may be a person who is acquainted with the writing and signature of that particular person. Third option is of the expert. Expert is not required to say that I know his writing. He, after scientific examination, he can say. So normally experts are not being examined. So once the document has been formally proved, means the document has been legally tendered in evidence and it is on record. The court is supposed to examine only those documents for appreciating the rival contention of parties which have been legally brought on record. There are so many documents on record, but the court is not supposed to go into all those documents. The only documents which we say for our facilities, procedure has been adopted and provisions have been made in the civil court rules that when the court admits any document in evidence, after adopting the procedure for proof as per the Evidence Act of that document, then it is being marked as exhibit. Once a document has been marked an exhibit, it means the court has admitted it for consideration in evidence. And that has to be considered at the time of writing out the judgment. But at that moment, the court is only required that all the standard of proof as prescribed under the Evidence Act has been complied or not. That is the sole criteria. Either he is a person in whose presence the document was made, then he will say that I witnessed the document when the document was scribed or when the document was being signed by such and such person. Then his evidence is direct evidence, because the rule of evidence is that direct evidence is preferable. If direct evidence is not available, then indirect evidence is preferable. Or he say that he was not present, but I know his writing. But merely by saying that I know his writing is not sufficient. That makes not that person a competent person to testify this issue that this is written by such and such person. Something nowadays I have witnessed in so many cases as a lawyer that evidence is not complete. A trial court lawyers do not pay much attention to what is simply stereotype evidence is being laid for proving any document that this is a document of will, it has been written by A, I know his signature. No further step is being taken. Only the evidence is in short that he knows the writing and document is formally marked as exhibit. That is not correct. Unless he established himself that he has a special knowledge, and on that basis he identified the writing and signature. And in order to establish the special knowledge, so far as identification of writing and signature is concerned, he must say on oath that either I worked with that person and I had occasion to see him writing, and therefore I am well acquainted with the signature and writing of such and such person. So this part is lacking in most of the evidence which nowadays I detected in several cases. So as the appellate court also, while appreciating the evidence, no doubt the document is on record once it has been exhibited, but it does not mean that it has to be accepted in evidence. Admission of a document in evidence by marking document is one thing, and its probative value which the court is required to assess is another thing. So the admissibility of the document in evidence and its probative value has to be examined later on, because at the time when the evidence is going on, the court is not supposed to examine each and every document at that moment, or any objection, if any objection is raised, to dispose of that objection, which would be a time taking. And therefore, this practice has been adopted, and procedure also says that if formal proof is there, the document shall be marked as exhibit. For that, if the document is of the plaintiff, recently I have come across in one case that relates to Bhavua, where I examined the record. So the exhibit numbers have not been properly been made. So as a trial court, it is to be seen. But you also, if you find some irregularity as appellate court, then you also may correct it. But it will reflect bad picture before the higher court. Suppose a document has been tendered on behalf of the plaintiff. The first document will be marked as Exhibit 1. Plaintiff has got numerical 1, 2, 3, 4 so far as exhibited documents are concerned. And for one document, one number is allotted. Suppose there are 4 sale deeds. One sale deed has been marked as Exhibit 1. Then another 3 sale deeds shall be marked in the same series. 1 by A, 1 by B, 1 by C. I have detected in one case just recently that a sale deed was exhibited Exhibit 1. And signature appearing on the sale deed, 3 witnesses and the scribe, that signature has been marked as 1 by B, 1 by C, 1 by D. It is not proper. It would create confusion before higher court in appreciation of evidence. So it must reflect from the exhibit list prepared by the trial court. And if there is a mistake, that can also be corrected by the appellate court. Sometime I detected that every evidence which is tendered before a court of law and any document is proved before a court of law, at that time the presiding officer who writes the deposition, he is also supposed to mention this fact, document so and so, after recording the evidence so far as proof of the document is concerned, document so and so be marked as Exhibit 1. So while the document is being admitted, it must reflect in the deposition first, then it must reflect in the order sheet of that day, and thereafter it also reflects on the exhibit list, which is supposed to be prepared by the court, but it is the function of the bench clerk or the office clerk who may be available to prepare that list. But that list also must be a day-to-day signature of the presiding officer. This is one aspect. Now, the technical aspect is that every evidence has to be appreciated in the light of issues. Because if there are divergences on facts or of law, according to Order 14 CPC, there may be an issue of fact, or there may be an issue of law, or there may be an issue of fact and law, that is mixed question of fact or law. So 3 types of issue are being normally framed by the trial court. If the appellate court finds that any issue which ought to have been framed but has not been framed, then the appellate court has got 2 options. Either the appellate court may frame that issue if evidence is already there, or the court has already discussed and gone into that evidence, but in absence of issue, finding has not been properly given. In that case, the trial court either remand the matter or reframe the issue. It does not debar the appellate court, because the appellate court is as good as a trial court, and whatever jurisdictions have been vested in disposal of a suit with the trial court is also available with the appellate court. In this context, provisions of Order 41 CPC are very relevant, and before explaining Order 41, because entire procedure for disposal of appeal, the appeal which are being filed in the district court are being registered as title appeal, because there in CPC prescribed 2 appeal, first appeal and second appeal. First appeal is being filed in the district court. So far as second appeal is concerned, is being filed before this high court. But nowadays, due to enhancement of the pecuniary jurisdiction of the court, if the valuation of suit exceeds the appellate jurisdiction of the district judge, which is nowadays 1 rupees less than 10 lakhs, means 9,99,999. If the valuation is such, the jurisdiction, the appellate jurisdiction is of the district judge. And if it exceeds that, means if it is 10 lakh, then the first appeal will lie. So as per the High Court rules, first appeal it is registered as a first appeal. But so far as district judge is concerned, in district court, it is registered as title appeal, which arises out of a pure title suit. If it arises out of eviction suit, then it is title bracket में eviction appeal. If it arises out of money suit, then it is called money appeal. So different type of appeals as per the practice and procedure and civil court rules are being registered, but all those appeals before the district court are first appeal. Even though it is registered as title will, but it is first appeal. So in this context, firstly, section 107, because section 107 gives the general provisions relating to appeals, and the appellate court has been empowered by this section 107. So while you are acting as a appellate court, you must be fully aware of provision section 107. If you have the book with you, you may take out the book, or you may take out this provision on your mobile. I am reading that for your appreciation. Powers of appellate court, subject to such conditions and limitations as may be prescribed. An appellate court shall have power. Powers have been given in 3 clauses, A, B, C, D, but there are certain limitations. And where are those certain limitations? Those limitations are in the code itself. If the matter purely relates to the CPC, there are other acts also, special acts, under which the civil court also functions. For that, there are other provisions. Therefore, it is not specified here that as subject to conditions prescribed in the CPC. Means some restrictions and conditions are prescribed in the CPC itself, and there are other acts, special acts, under which the district court exercises the appellate jurisdiction. In that, there are certain conditions. But the first power is to determine a case finally. The placement of these 4 clauses by the legislature in section 107 is very important. Why? First and foremost duty of the appellate court is to determine a case finally. Means remand of the case should not be a regular feature. It must be under special circumstances, to which I will come later on while discussing the provisions of Order 41. Its second option is to remand a case. You have the power to determine the case finally. So first and foremost duty of the appellate court is to determine the case finally. Means on merit you have to decide it. It has to be decided on merit. This is the first option. Second option is to remand a case. C, third, to frame issue and refer them for trial. The B says remand means total remand. If you set aside the judgment on any ground that is prescribed under Order 41, to which I would discuss later on, after setting aside the judgment of the trial court, you have been empowered to remand the case. It is called total remand. But subclause C says partial remand. Just before I have mentioned that when the trial court failed to frame a particular issue which ought to have been framed as per the provisions of Order 41, Rule 1, CPC. The trial court has failed in its duty, and the appellate court finds it convenient and just or proper that this issue should be there. The court may frame issue and dispose of the matter. But C says, clause C of section 107 says that you may frame issue and refer that issue for trial before the lower court. Means on that issue, if you feel that certain evidence are required, if you want to put any question, no. If you decide that particular issue has not been framed and it ought to have been framed by the trial court, then it is called partial remand for that purpose if the matter is remanded to the trial court. The only difference in partial remand and full remand is that if there are evidence available, either oral or documentary, on the basis of which the trial court judgment has also some discussions, or it has no reference or discussion, but evidence are on record, either oral evidence or documentary evidence. In both these situations, if the court finds, the appellate court finds convenient that the court is in a position to dispose of that issue on the basis of available evidence, then remand has been discouraged by the Supreme Court. In that case, endeavor should be made by the appellate court to frame the issue and to take assistance of all those evidence, and after a scrutiny of those evidence, give a positive finding on the basis of the evidence available. But where evidence is not available, issues have been not framed, and parties have also not evidence, or insufficient evidence is available. In that case only subclause C would apply, and then the appellate court may frame issue which was missing, which the trial court for any reason whatsoever omitted to frame. Then the first appellate court shall frame that issue and refer that issue to the trial court for trial. Means the evidence which is required in context with that issue, either oral or documentary, shall be taken or recorded by the trial court, and the trial court shall give a finding on that particular issue only, because only one issue has been referred. It is called partial remand. And after taking evidence or giving finding on evidence, the record will be again transmitted to the appellate court, and then appellate court shall decide in all the issues, because Order 41 says that the court is supposed to decide all the issues. It is the duty of the court to decide all the issues. And one issue was missing, that issue was framed subsequently, matter was remanded, the trial court framed that issue, took evidence and gave finding, referred the matter to the appellate court, then appellate court shall decide that missing issue along with all other issues. Then final judgment will be passed. Then subclause D says to take additional evidence or to require such evidence to be taken. All of you are aware, Order 41 Rule 27 is there, that appellate court has got jurisdiction and power to take additional evidence under the conditions which has been prescribed in that provision. Then subclause 2 is important, which I want to bring to the notice of all the officers. Subject as aforesaid, the appellate court shall have the same powers and shall perform as nearly as may be the same duties as are conferred and imposed by this court on courts of original jurisdiction in respect of suit instituted therein. Therefore, I laid emphasis at the very beginning that suit is being tried by the trial court, and the first appeal is being tried by the appellate court. The function of trial court and appellate court is not different, exactly same, power is same. Whatever power is vested with the trial court, the same power is vested with the appellate court. But additional power that the appellate court possesses is to find out the legality or illegality of the judgment. For that yardstick is whether the trial court has properly appreciated the evidence or not, whether he has considered any document or not, whether some document has been left out of consideration, or there is a misappreciation, wrong approach has been taken by the court below. There are certain evidence which are not admissible in law, certain documents which have not been properly been proved, it is not legally admissible, so and so forth. All these matters are to be considered to find out any infirmity, illegality, or wrong in the judgment of the trial court. It is additional power vested with the appellate court. So it is first and foremost duty of the court to examine the oral and documentary evidence meticulously. Otherwise, you may commit wrong also. I will show certain judgments also. Most of you must be aware of it also, that either you may confirm the judgment of the trial court or affirm the judgment of the trial court, or you may modify it to some extent in particular issue or in some matters, or you may set aside it completely and rewrite the fresh judgment. If you want to affirm the judgment, I have come across certain judgments which are not sustainable before the High Court, which says that the trial court has considered every aspect of the matter, he has gone in detail with the oral evidence and documentary evidence. I do not find any infirmity in the judgment of the trial court, and therefore there is no merit in the appeal, or therefore the appeal, judgment is affirmed. That judgment is not sustainable in the eye of law. The second appellate court set aside your judgment. Your judgment must show application of judicial mind to each and every evidence. Means you are supposed to act as a trial court for a scrutiny, a reappraisal and examination of document, and to give effect of those document and evidence in accordance with the rule of evidence, that whether the party has been able to establish their case as per the issue framed by the trial court on the basis of those oral and documentary evidence. But Supreme Court in some of the judgment has said that when after examining and reappraisal of oral and documentary evidence, the appellate court finds that there is no infirmity in the judgment, then lesser duty is cast upon the appellate court. Means you are not required to discuss in more detail each and every evidence. But it does not mean that you will not go into the details of it. You are required to go into the details, but not so deeply. And if you want to reverse it, judgment completely, set aside it, then your duty is more heavy. And whatever finding has been given by the trial court on the basis of particular evidence, oral or documentary, we will have to examine that oral and documentary evidence and point out the irregularity or illegality or wrong which has been committed by the trial court. That due to this reason, the witness has not, the court has not properly appreciated whatever he has said. You can even interpret the evidence of the witnesses, you can interpret the contents of the document, you can also interpret the implication of that document and applicability of any provision of law on the basis of which this document has got no probative value on the issue concerned. So duty is heavier in a case when the appellate courts want to set aside the judgment of the trial court. So each and every witness, each and every documentary evidence has to be examined meticulously, and after examination you have to rewrite the judgment independently at your own wisdom and knowledge based on those documents. You are not required to be influenced by the findings of. You are supposed to write a fresh judgment, not exactly in the line of the trial court. Even if you were supposed to confirm the judgment of the trial court, then you are also required to write judgment in your own way. You may concur with the finding, or you may accept the findings given by the trial court. But by saying that this witness is on this point, his evidence says something in order to prove this fact in issue, he has brought this document and this witness has proved this document and court below has given finding on this document which does not require to be interfered with because it is in consonance with law. It must reflect from the appellate court judgment that the trial court has considered every material evidence on record. The trial court has considered properly the finding of the trial court, and after consideration of finding of the trial court as well the material evidence which are in the shape of documentary evidence or oral evidence, then the appellate court may give its own finding. Now the difference is the trial court is supposed to frame issue of fact, issue of law, or mixed question of fact and law. And therefore, ordinarily, the appellate court is not supposed to frame its own issue. But I have come across certain judgment of the appellate court in which I have detected that the appellate court has also framed its separate issue. Sometimes adopted the same issue framed by the trial court, or sometimes rewriting of the issue has been made by the appellate court. That is not proper. What is required to be done by the appellate court is to frame points for determination. That you will find in Order 41, Rule 31 CPC. Points for determination are required to be framed by the appellate court, and your finding would be based around that point for determination. Firstly, just like issue, but there may be 10 issues, 5 issues, 6 issues, but there may not be on similar line several points for determination. It is typical point on the basis of which the appeal can be disposed of. Means gist of all those points. Suppose first point is normally in every case whether the trial court has committed error in passing the judgment. This may be a point for determination. Whether the trial court has committed error in holding that the suit is barred by limitation on the basis of material evidence available on record. Such type of points may be framed. Either it may be points on the basis of facts or may be on the basis of. So, Order 41, Rule 31 would be a proper guide for every appellate court at the time of writing out the judgment. Firstly, the case of the parties are required to be written in the judgment. Then the finding of the trial court, issue framed by the trial court, all those things are required to be referred. But where the trial court is supposed to act is it starts from the point of determination. Background, whatever you have written, there is no mistake in it because it has been completely known to all of the presiding officers holding an appellate court that whatever finding is given by the trial court is also required to be mentioned in the judgment apart from the pleading of the parties and evidence considered by the trial court as per the issues framed. So in this situation, you are only required to frame points for determination. And Order 41 Rule 30 says that how those points shall be considered. So reading together Order 40 Rule 30 and Order 41 Rule 31 makes a complete picture how to act as a appellate court while deciding the civil trial. So I especially pointed out section 107 subclause 2 because sometime I have been asked with some questions on this line that how the appellate court will act as a trial court. At this juncture, I would also like to point out one provision. All of you are also aware of that provision, that is section 24 CPC, which gives the district judge power of transfer civil case from one court to another court or from one subdivision to another within the district. The district court has jurisdiction, means district judge has jurisdiction. So all of you are, while disposing of appeal, are as good as district judge. You are well aware, the constitution says, Bengal Agra Assam Civil Court Act says that district judge includes additional district judge. District judge is only administrative head. When the case is being filed before the district court, district judge used to exercise his power of transfer and transfer the matter to the additional court. So once the appeal has been transferred to the additional court becomes district judge for the purpose of deciding the appeal under CPC. Designation is additional, but whatever power is vested with the district judge is the same, exactly the same power to the, there is no curtailment of power. There is no curtailment. Both are at par. One is only administrative head. So far as judicial function is concerned, both have equal powers. So once the matter has been transferred from one court to other court, the district judge has been given power at the same time to withdraw the suit in his own file. And after withdrawal, he may dispose it off. Means the district court has got also original jurisdiction of trial. I would like to point out at this juncture so that there may not be confusion on this issue. Section 24. Section 24 is general power of transfer and withdrawal. On the application of any of the parties and after notice to the parties and after hearing such of them as desired to be heard or of its own motion without such notice, the High Court or District Court may at any stage transfer any suit, appeal or other proceeding pending before it for trial or disposal to any court subordinate to it and competent to try or dispose of the same. You may say here, this is the power of transfer, but additional district judge court is not subordinate court. It is not a subordinate court of district judge. But here it has been used for the purpose of transfer only. Subclause V, withdraw any suit, appeal or other proceeding pending in any court subordinate to it. So it should not be confused. The appeal can also be drawn, appeal can be also transferred to the additional district court, which is not subordinate. As per the Civil Court Act, additional court is not a subordinate court, but here for the purpose of transfer, the word subordinate has been used by the legislature here. Then withdraw any suit, appeal or other proceeding pending in any subordinate court to it. Try or dispose of the same. यहीं पर लिखा हुआ है try or dispose of the same. What it means? If suit has transferred from any court, the district court can try it. But it means district judge himself can try it, or he may transfer it to the additional district judge. So even the suit can be also tried by the district court. That is what I want to convey at this juncture. And for your knowledge and experience, I would like to point out one case, which is a very important case in which the Patna High Court has transferred a suit from Darbhanga sub-judge and tried for trial. I started trial of that matter. But that is the only one instance. So far, this power of transfer and power of trial is concerned. Not only district court, even the High Court can also try. Though Patna High Court, which is a chartered High Court, you are all of you are aware that in India we are having two types of high courts. One is pre-constitution high courts and post-constitution high courts. Pre-constitution high courts are chartered high courts, and among those chartered high courts, Patna High Court is also one of the chartered high courts, which was constituted under the charter granted by the British Empire under the provisions of Indian High Courts Act 1811. But the charter does not empower the High Court to try the suit. Means Patna High Court has not original jurisdiction for the trial of the suit. Though in other matters, writ jurisdiction is also at original jurisdiction. Matrimonial jurisdiction is also original jurisdiction. And testamentary jurisdiction is also original jurisdiction of the High Court, which the Patna High Court possesses. Testamentary cases. Because under the provisions of Indian succession, and in second half, I will discuss on that point, but at this juncture, by way of passing reference, in Indian Succession Act 1925, everywhere the word district judge appear. So sometimes it is being confused that only the district judge has got testamentary power, probate, and letter of administration of succession certificates are being granted exclusive by the district judge. But it is not true. Section 300 has been prescribed in that act, which says that the High Court shall have concurrent power and jurisdiction. So why Section 300 was enacted in 125? Because of the fact that the Patna High Court was constituted much earlier in 1916. This act was passed in the year 1925. So it means the legislatures were aware of this fact that the Patna High Court does not possess a jurisdiction, original jurisdiction, so far as testamentary matters are concerned. Therefore, by virtue of Section 300, that jurisdiction was conferred. So now the district court and the High Court is at par so far as testamentary matters are concerned. It is option of the party either to approach the district court or to approach the High Court. So similarly, under Section 24, you possesses that power. As an additional court, you will exercise this power when the district court, yani ki district judge, shall exercise his jurisdiction under Section 24 and transfer that suit in your file, then you are also competent to try it. And when you try it, then you will act as a trial court. So these are the basic principle of appreciation of evidence in the appeal, first appeal. Because first appeal is a final appeal of fact. And you as an appellate court is a final court of fact. Therefore, heavy onus lies upon the first appellate court, which is not on the High Court as a second appellate court. But your duty is more heavier than High Court while deciding a first appeal. So it is a very important matter, and exercise of judicial discretion and jurisdiction vested with the first appellate court according to the CPC is more important. Because if any finding has been given by the trial court and that finding has been upheld by the first appellate court, then it is called concurrent finding of fact. Once a concurrent finding of fact has been given, then the High Court jurisdiction is ousted. High Court cannot entertain second appeal against the concurrent finding of fact. That finding is binding upon the High Court. So High Court's jurisdiction is very limited. As per Section 100 CPC, High Court jurisdiction is to entertain second appeal on the basis of substantial question of law. And this substantial question of law has not been defined in CPC or any other act, but it has been evolved by the judicial pronouncement of the Supreme Court and High Court. What are the substantial questions of law? All questions of law are not substantial questions of law. The questions which have already been settled by the apex court, that these questions would be considered as substantial questions of law on the basis of which only the High Court will entertain. We have experience as a High Court practitioner that 90% second appeal are being dismissed because of the situation that there is concurrent finding of fact. If trial court has committed error of fact, and you as a appellate court would also commit the same error on any ground or any count whatsoever, in that context, you may commit a mistake because that party become remedialist. Second appeal would not be admitted. There are certain exceptional situations under which the second appeal may be admitted despite concurrent finding, but that is a remote chance of admission of second appeal when there is a concurrent finding of fact. That is an exceptional circumstance. But as a general rule, as per the principle decided under section 100 CPC, every second appeal shall be admitted when there is a substantial question of law. In a case where there is a concurrent finding of fact, there is no substantial question of law. This is the basic principle. Therefore, at this juncture, I would like to point out only that you, while acting as an appellate court, heavy duty is cast upon you to go into the details of the pleadings, appreciate the documentary and oral evidence, and examine the findings given by the trial court meticulously and arrive at an independent conclusion by application of judicial mind and correct and proper application and appreciation of law, and to give a positive finding on the points for determination which is supposed to be framed by the appellate court. And thereafter your judgment would indicate at the end that whatever relief has been given by the trial court, if you have set aside, there is no question. If you have set aside the judgment of the trial court, then there is no question of giving any positive finding. Judgment is set aside, appeal is allowed. That not ends the duty of the appellate court. If the judgment is set aside and appeal is allowed, then what is the positive finding which you have given? The operative portion of the appellate court also, positive finding or direction may be given. Whatever finding have been given by the trial court, either in the same form or when you are upholding or in your own way, the judgment also may reflect that this is the finding of the appellate court. But normally I have seen that the judgment of the trial court is set aside, appeal is allowed. So from the appellate judgment, nobody can, because the decree would be prepared on the basis of that judgment. The decree does not reflect what finding has been given by the appellate court. For that, if you want to put that decree in execution, there may be problem. For that, judgment is required to be filed. Therefore, just like trial court, when the trial court gives in the operative portion whatever finding have been given, the gist of the judgment must reflect in the operative portion of the judgment of the trial court. This is normal practice which are regularly given, and decree is being prepared, and that decree also reflects, because the law says that judgment and decree must agree. One may, after going through the decree, consider and appreciate that whatever finding has been given by the court concerned in the judgment. So from decree, there must be reflection of the judgment in the decree. Similarly, as an appellate judgment, the judgment of the appellate court in operative part must reflect whatever finding you have given. If you have concurred the finding, then also you are required to make it in it. If you have set aside the judgment and allow the appeal, then or not remanded, then whatever finding you have given, that plaintiff has got no case, suit is barred by limitation, or whatever may be the grounds, it must be. If you have modified it, then certainly your duty is more heavier to give those modified finding in the operative portion also. So in the body of the judgment, while you are discussing that is also required to be mentioned, and concluding part in the operative part of the judgment, it also must reflect. Now, I come to the provisions of 41. I think we have completed the time. It is 11. क्लास आप लोग ब्रेक करना चाहेंगे कि कंटिन्यू करें?
सर जैसे आप ठीक समझे, आप ब्रेक कर लीजिए.
नहीं, जब और ऑप्शन लोग दे आर एकस्टम्ड ऑफ हैविंग टी, ठंडा का समय है तो कहेंगे कि आप भाई आई विल इंक्रोच।
टी ब्रेक करा दीजिए।
टी ब्रेक के बाद आधा घंटा के बाद मिले हम लोग,
ठीक है सर।
ठीक है?
जी जी सर।
ऑल एग्री?
सर इस सर्दी में आपका वार्म सजेशन जो है वार्मली वेलकम्ड है सर।
अच्छा, थैंक यू। ठीक है, चाय पीजिए, चाय पी के फिर फ्रेश हो जाएंगे।
आधे घंटे के बाद फिर
हाँ, आधा घंटा के बाद मिलते हैं, ठीक है? ओके।